Hi, thanks for using my court coach. I'm Sarah, and I'll be your instructor today as we talk about the response to notice of motion to cancel or set aside a judgment of parentage, also known as Form FL-276. As with all our court forms, you want to start off by filling in your identifying case caption information at the top. Below that is the place to list the hearing date, time, and department. You can just copy that information over from the motion that you were served with. Then below that, you need to indicate if you agree with the information regarding the judgment of parentage that was provided in the motion you were served with. That information can be found in item 6. Basically, it just states the date of the judgment of parentage, that the date it was entered, the county it was entered in, and any information about the children, including name of child, birth dates of child. So if there's something that you don't agree with that's listed in that form, then you want to correct it and mark box 1B and indicate what specifically you don't agree with. Next, you need to indicate if you would agree with the request to submit to genetic testing. If so, mark box 2A. If you do not agree, mark box 2B and explain your reasons why. If the notice of motion requests that a guardian ad litem be appointed for the child at issue, and that is an adult that is appointed by the court to serve as that child's advocate, then you would want to mark box 3A if you agree to that appointment, and mark box 3B if you do not agree to the appointment. Next, you would want to, if you do not believe that the notice of motion is complete, then you would mark box 4 and then indicate what you think is incomplete about the motion. If you think that the request is not timely made, mark box 5 and indicate why you don't think it was timely made. And remember that a motion to set aside a judgment of parentage needs to have been brought within 2 years after the original judgment of parentage was established, or within 2 years of when the person filing the motion should have known about the judgment being entered. Next, if you believe that the request is not proper, mark box 6 and explain what you think is not proper. And if it's based on one of these reasons listed below in item 7, you can just say see below, that's fine too. And just to go over those reasons, if the judgment of parentage resulted from a divorce or legal separation or nullity, or if it was based on the fact that the parents of the child were married and living together as spouses at the time of conception and birth, then you cannot file a notice of motion to set aside. So you can mark either 7A or 7B if you believe those situations apply. If the parentage judgment was not issued in California, you cannot file this motion to set aside. So you can mark 7C. If there's a different California judgment of parentage in a different case for the same parent and child, mark box D. If there's a voluntary declaration of parentage or paternity and there is no basis to set it aside, you can mark box 7E. Just so you know, a valid basis to set it aside would be based on fraud, duress, or material mistake of fact. And if it's a voluntary declaration of paternity that was signed before January 1st, 2020, it can also be based on mistake, inadvertent surprise, or excusable neglect of the person who supposedly signed it. If there has been genetic testing already conducted that indicated that the previously established parent is the genetic parent of the child, then you can mark 7F. If the parentage judgment was based on adoption, mark 7G. If the child was conceived by artificial insemination and the parentage judgment was based on Family Code Section 7613, you can mark box 7F. And just so you know, to summarize quickly, Family Code Section 7613 states that if a woman conceives through assisted reproduction with the consent of the other intended party, that intended party is treated as the natural parent of the child, and that consent can be proven by written agreement and in some instances oral agreement. So if you fall under that scenario, you can mark box 7F. If the child was conceived under a surrogacy agreement, you can mark box 7I. If you just don't think it's in the best interest of the child, maybe the child is extremely bonded to the person that's been found to be that child's parent, for instance, or whatever other reason you think that it wouldn't be in the best interest of the child to set aside the judgment of parentage, then you can mark box 7J and specify the reasons. If there's any other reason that you think the request is not proper or that you want the court to consider in making this determination, you can mark box 7K and list what those reasons are. If this is not enough space for you, you can always attach another sheet of paper to this and just mark the box that says contained in the attached declaration to let the court know that these facts have been continued onto another sheet of paper. Finally, you want to print your name at the bottom, sign and date it. This form will have to be served on the other party. You need to have someone that is over the age of 18 and not a party to the case fill out this section, page 3, the proof of service. They will indicate that they have either served the other side by personal service, and then they need to mark box 2A and identify the party served, the address where served, date and time of delivery. If there's a local child support agency involved as well, then they will need to be served, and this box will need to be checked indicating that. If the service was done by mail, you can have your process server mark box 2B. Again, they're going to have to list the name of the party served, the address, date, time, or date and place of mailing, city and state. The process server then needs to fill in their name at the bottom, sign and date, page 3 of this form, and this form is now ready to be filed as your response to the request to set aside the judgment of parentage. I hope you found this helpful. Good luck.